person. There we go. All right, this is in the matter of the people of the state of Michigan versus Denver James Warner, file number 24-21676FH. I have Isaac Sneed appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. Warner. This is the date and time set for a pretrial conference in this matter. Mr. Murphy, hold on one second. From the day, I guess from the jail, if you want, I can take Mr. Clark or Mr. Big. Mr. Bixler is not till 10. Maybe Mr. Clark next. And Becky, can you call Mr. Daly and get him here?
Mr. Can you have your secretary call me on Mr. Clark?
Yeah. Yep. All right. Okay. All right. So, Mr. Murphy, how do you want to proceed today on behalf of Mr. Warner?
Your Honor, I was in discussion with Ms. McClure about this matter. I was going to ask to adjourn for another pretrial and for Mr. Warner to contact my office to schedule an appointment so I can discuss the offer with him and we can decide what we want to do at the next pretrial date.
All right. So, I'm going to set this over for another pretrial on February 28th at 8:30 in the morning. And I'm going to get you a notice of hearing. So I'm going to have you sit on the bench and wait. And then I need you to stay in contact with Mr. Murphy. So like a week before your next court date, call and set up an appointment with him. All right. And make sure you have voicemail set up on your phone so that he can call you. All right. Okay. All right. So have a seat there. And Miss Adams, I know I just asked you to do three things at one time.
Yep,
but
Judge,
when you get a chance.
I missed the date is all.
I know. I was just going to tell you, I set it for February 28th at 8:30, so I'll need a notice of hearing.
Okay, thank you.
And you are here with Mr. Murphy, right?
Yes.
Okay, so I don't think, what did Sierra say? Sierra said, like Martin, right?
Barton, yes, sir.
Oh, okay. All right, so is Blake Barton here? No.
He's been on Zoom previously.
Okay, so I'm gonna call the case because we're not gonna do anything on, oh, he just popped in. Nope, I must have heard me. Okay.
Judge, did you say Martin?
No, I'll call it. It's Barton.
I don't have it though. I don't have the doc.
I don't know. Yeah, it is. It's page 2, first 8:30.
Oh, I'm sorry, Judge. Thank you.
Okay, so this is in the matter of the people. Well, he's not connected to audio. All right, this is in the matter of the people of the state of Michigan versus Blake Anthony William Barton, file number 23-21272. FH. I have Matthew Murphy appearing on behalf of Mr. Barton, and I have Alexander Bayonetto appearing on behalf of the people. This is a date and time set for pretrial. There was a motion that I granted in limine to exclude evidence. Mr. Bayonetto has filed a motion for reconsideration. We ordered a response from Mr. Murphy, which we got this week, and I'm in trial. So I haven't been able to review it. So we will get an opinion out by the end of the week. And I can set another pretrial if you'd like, Mr. Murphy and Mr. Bayonetto.
I think that'd be wise.
Mr. Murphy?
I didn't know if we'd want to set a trial and final pretrial, if that would be better just to get a trial scheduled, or I
Just gonna
guess.
set a pretrial for next week and we can schedule a trial date at that time.
Okay, that's fine with me.
Okay, so I'm gonna set this actually for Valentine's Day. So pretrial on February 14 at 8:30 in the morning. All right?
Thank you, Your Honor. Your Honor, could I have a breakout with Mr. Barton if it's not going to impede you right now?
No, it won't impede me, so I will do that. All right, and the gentleman's right there, Mr. Warner.
Thank you.
Oh, okay. All right, Mr. Barton, I am going to open up a breakout room and assign you and Mr. Murphy. And there you go. Go ahead and join that breakout room. All right, Mr. Daly. No, Mr. Daly, come back. Yeah. Actually, give him this and tell him we won't be able to do this, Clark, today. Okay. But I am maybe ready on this other one. Okay. So defense attorneys, who do I have? I have Michael Jagger Margosian. And he has Castro Oliveras. I guess from the jail, I can start taking, I can take Mick Phelps.
I'll get him.
All right, thank you.
I checked those, Judge Olson, unless he went to the bathroom.
Okay, okay. All right, well. I'm looking. Castro Oliveras in the courtroom? No. All right, Mr. Dagger Margosian, do you want to reach out to Castro Oliveras?
Your Honor, he doesn't have a working phone right now. He was in court yesterday on a different matters, and he's aware of this. So I'd expect him to be here soon.
Okay. All right, we can wait.
Okay.
I'll find out who this. All right, I have someone named Jonathan. Can I have your full name, please?
Jonathan Garnier.
All right. Mr. Daly is your attorney, so I'm going to change your screen name just so I don't forget that. Mr. Daly is here, so I'm just waiting for him to come back in the room. So I'm going to pop in the waiting room. Pedro Hernandez. Oh, I'm going to pop him back in. Hi, Mr. Daly.
Yes.
Why don't you come on up? I have Mr. Garnier here. And I'll call Clark and I'll get another date for that, all right?
Okay.
All right, in the matter of the people of the state of Michigan versus Dennis J. Clark, file number 24-21696FH. I have James Daly appearing on behalf of Mr. Clark and Isaac Sneed appearing on behalf of the people. Mr. Daly, this is the date and time set for arraignment in this matter, and it's my understanding that he is no longer at the Lenawee County Jail. He's at the jail in Jackson. So, Mr. Sneed, to do a writ from Jackson, would you need about 2 weeks?
Yes, thank you, Judge.
Okay, so I'm going to set this over to Valentine's Day, Mr. Daly.
Okay.
And,
That's right.
at 8:30 in the morning, and can you do the statement order to adjourn?
Yes, Your Honor.
Okay, so we'll set Mr. Clark or Miss Adams.
I can do the notice. It's an arraignment.
Oh, it's an arraignment. We do the notice. Okay.
Okay.
So we'll see you back on Mr. Clark on February 14th, and I'm sorry I misspoke at 8:15. All right, so now I have Mr. Garnier.
Yes, ma'am.
So let me grab his file. Is it Garnier or Garnier?
It's Garnier, but Garnier works.
No, whatever. So I have one of those names people can't pronounce, so I always try to be correct. So
It's like the
Garnier.
shampoo. It's like the shampoo.
That's what I was thinking when I said it. Yeah. All
Yes,
right.
ma'am.
This is in the this is in the matter of the people of the state of Michigan versus where I don't even grab this file. Hold on. No, where's it? What did I do with it? Well, I don't even know what I did with this file. Let me find it, Mr. Daly. Garnier, and it is file number 23-21651 FH, 23-21652 FH, 23-21653 FH. There it is. I have James Daly appearing on behalf of Mr. Garnier, and I have Isaac Sneed appearing on behalf of the people. So, Mr. Daly, how would you like to proceed today?
Yeah, Mr. Steed and I had an agreement worked out. So if Mr. Hernandez would plead guilty, he would be accepted into the Veterans Court. His problems occurred as a result of coming back from overseas and the PTSD that occurred with that. And he was out of control for a while. Now he's not. He's doing well. He has a car, has a home. He's raising his children. He's doing great. But he doesn't want to plead now because he thinks he's pleading guilty to a felony. I told him he was pleading guilty to a felony that would be dismissed when he completed the court. But he doesn't get beyond that concept that he'd be pleading on something that's not going to be. And so he won't plead on the felony right now.
And who's your prosecutor?
Again, and see if I can get it straight.
Who's your prosecutor?
Huh?
Who's the prosecutor?
It wasn't Mr. Sneed.
Oh, Mr. Sneed. So what is the plea offer on this?
Your Honor, in file ending 5-1 FH, the offer was as charged to home invasion second degree. In file 5-2 FH, it was as charged to count one, carrying a concealed weapon. And the people would dismiss a district court assault case as well as the felony absconding case in 5-3 FH. In addition, the defendant would forfeit the Taurus 9mm. He'd have no contact with the victims, and he would have to engage and successfully complete the Veterans Treatment Court, where the judgment of guilt would be deferred for him to successfully complete that.
Okay. So, Mr. Garnier.
Yes, ma'am.
It gets kind of complicated sometimes. So basically what it is you have 3 felony files, right? And
Yes,
so we have a thing called a deferred sentence, which means that if you, am I correct, Mr. Sneed, this would then, so if he would plead, it would be taken under advisement. The sentencing would be deferred or delayed. And if he successfully completes everything, the conviction would go away.
Correct.
All right. So, Mr. Garnier, when you go talk to Mr. Daly, what it means is you plead, and as long as you're successful on probation and complete your Veterans Court program and basically get the help that we can give to you, then you would not have any convictions and no felonies on your record. So
what I was wondering is if during the time of me going through Veterans Court and completing the program, which I have no problem doing, I know I need the help, and it, you know what I mean? I'd be more than willing to do it. But while I'm doing that program, if I were to go get a job or try to, you know what I mean, simply apply for a passport, would it come up is that I, you know what I mean, I have felonies on my record.
So
until it's completed.
Sneed, correct me if I'm wrong. Your record will always show that you had charges, but if it's under a deferred or delayed, Mr. Sneed, it doesn't go into lien, correct? As a conviction.
Your Honor, with the deferral for Veterans Court, for the Michigan State Police criminal history reporting, the report shows a deferred judgment of guilt. For the caseload reporting, it is reported as a guilty plea. The court record status would be non-public at the time of the deferral.
So
a judgment of guilt is not entered.
Yeah. So Mr. Garnier would not show as a conviction for the public. But one of my terms of probation is you can't leave the country anyway. So you probably have to wait to get a passport until after your probation's done.
I understand that, ma'am.
Yeah. But other than that, so why don't you take the time, go meet with Mr. Daly and he'll go through it with you again. And Mr. Daly, why don't I set this out to February 14 with your other one?
That's fine, Judge.
All right, so I'll set it out. If he decides, Mr. Daly, to plea, then let Miss Adams know and I'll bring him in on a day other than a Wednesday.
Thank you, guys.
All right, thank you, Mr.
Thank you.
Daly.
Hey,
Thank you, ma'am.
Jim, have
And
you
Mr.
sent,
D-
have you sent a referral to us for him to be screened for Veterans Court?
Not yet.
Okay. All right, because I haven't
All right.
received.
So can you do that today? Can you send the deferral for Veterans Court today, referral?
Yes.
Okay, we'll send that today, Ms. Teskey. Ms. Teskey, do you want a breakout room with Mr. Garnier just to get his contact information?
No, usually when Mr. Daly sends that to me, he'll send me all that.
Okay, so Mr. Garnier, you may receive a call that says unknown or from the state of Michigan. Make sure you
Okay.
pick up and at least
Okay.
make sure your voicemail's set up so you can receive the voicemails, all right?
Okay, thank you, ma'am.
All right, thank you. Mr. Daly, you'll do the stip in order to adjourn?
I will, yeah.
All right, thank you. All right, Mr. Daly, that's all I have with you, right?
We've got Bixler 10.
10 o'clock. Yep, Bixler. I'll see you back.
Okay.
Thank you. All right, I have, all right, who do I have? Not Mr. Loney, but who do I have in the other jail room? Is that Mr., are you Mr., who are you? Mick Phelps? Yep.
Yes.
Yep, okay. All right, so. All right, hold on just a moment. All right, Mr. Loney has been with us for a little bit this morning, Miss Underwood. So can I start with him?
I need a breakout with Mr. Loney. Thank you.
All right, you got my email, right? I'm giving very few breakout rooms this morning because I have a trial that needs to start at 10:30. So you only get like 2 minutes. I sent an email to all the attorneys, so you get about 2 minutes. All right, Mr. Loney, I am going to put you in a breakout room with Miss Underwood, but you guys will not have much time to talk, so go ahead. Mr. Murphy, who else do you have?
I have Pedro Hernandez. Is he
Got it.
zooming?
He's here. He was here in person, but then he left to go Zoom, so.
Could we place the offer on the record? I haven't been able to speak with him since the cops. His phone isn't connecting.
Hold on a second. Let's get him in here. All right, Mr. Hernandez, I need you to unmute your device, please. All right, there you go. All right, good. This is in the matter of the people of the state of Michigan versus Pedro Hernandez, file number 23-21526FH. I have Isaac Sneed appearing on behalf of the people. And I have Matthew Murphy appearing on behalf of Mr. Hernandez. I have an email in my file from Phoebe McClure to Mr. Murphy and my staff, not to me. And it basically states that there is an attached plea agreement from Mr. Hernandez. This does not reflect Judge Anzalon's recent COPS agreement to 30 days Illinois County Jail suspended, except for the 48 hours to be served on a weekend. So my understanding of the plea offer is that Mr. Hernandez is offered the ability to plead guilty to OWI third offense or as charged, and that he will receive probation. And then per statute, I must order 30 days in jail, but I will defer the balance other than the mandatory 48 hours. And then I can schedule that on a weekend and whatever terms of probation that I put in place. So is that a correct recitation of the plea, Mr. Sneed and Mr. Murphy?
Yes, Your Honor.
Yes, Your Honor, and unfortunately, I haven't been able to speak to Mr. Hernandez
All right.
since.
Because Mr. Hernandez is not in jail, I can either give you a quick breakout room because he won't bog down my jail ones, or I can set it over
Well, Mr. Hernandez, did you hear the offer? Do you want to plead guilty today?
Yeah, I still want to speak to you though.
Can we speak for a
Okay.
minute, Your Honor?
Yeah, he's not in jail, so I'm not too worried about that.
All right.
All
thank you.
right, so let me close my breakout rooms.
Your Honor,
And
I never found.
hold on, Miss
Mr.
Underwood, I'm doing one thing at a time. Give me a minute. All right, Mr. Murphy, I am going to put you and Mr. Hernandez into a breakout room. Go ahead and join. All right, Miss Underwood, I've got your client or Mr. Loney back. So Miss Underwood,
I never found him in the breakout, Your Honor.
okay. I'll put him in the breakout room again. All right, Mr. Loney, I'm gonna send you to a breakout room again. He went, so there you go, Miss Underwood. He's in the breakout room.
Thank you.
All right, so just a reminder, anybody have Matthew Murphy in the courtroom? Anybody have Michael Dagger-Margosian in the courtroom? We all have Ron Underwood in the courtroom. Okay. All right. Mr. Dagger-Margosian, your client is still not here. I also have an order for fingerprints still. And you wanna, you said, did you say you weren't able to reach him by phone?
His phone is off. So I
Okay,
don't have a way
but he
to,
was in court yesterday, right?
he was in court yesterday.
Okay. So Mr. Sneed, he was in court on another matter yesterday. So this is a pretrial. Are you okay proceeding without him?
Yes, Judge.
Obviously, okay. So in the matter of the people of the state of Michigan versus Castro Cash Oliveras, file number 23-21358 and 23-21499 FH. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger-Margosian appearing on behalf of Mr. Oliveras. He is not present, but since he was in court yesterday on another matter, I could see where there could be some confusion. So we are set for jury trial on January, no, what? We moved the jury trial, didn't we? Okay, so where do we stand today, Mr. Dagger-Margosian and Mr. Sneed?
Well, Your Honor, as the court indicated, one of these cases was scheduled for jury trial. That case was moved. We just need to get one of them rescheduled for jury trial. And that's all we need to accomplish today.
Okay, so Ms. Adams, his trial on file number 21358 FH was originally, well, let me see, set for January 11th for one day. So I'm looking for a one-day jury trial and he is not in custody.
All right.
We could do Tuesday, March 5th.
Are you both available Tuesday, March 5?
Your Honor, I have a trial the next day. If possible, I'd prefer a later date.
Okay, next available, please.
Tuesday, March 19th.
Does that work for you, Mr. Dagger-Margosian?
It does, thank you.
Mr. Sneed, I know this is
Mr. Fleming has a jury trial and Judge Olsavers on that date and time on a Daniel Kennedy.
next date, Ms. Adams.
Wednesday, May 15th.
Wednesday, May 15th.
Yes, thanks, Judge.
That's fine. Thank you.
All right, Wednesday trial date is at 10:30. So May 15 of 24 at 10:30 a.m. Obviously, we know that it probably will extend into the day 2. I will set both for pre-trial on May 1 at 8:30 in the morning. And I will require, I know that I've already been provided some, but I will require that I receive all voir dire questions and jury instructions by April 24. And no, I don't have. And I will, let's see. 24. And I will set a motion deadline for May 1, 24. And I filled out a scheduling order, so we will mail that out. I don't have the agreement deadlines, so that doesn't matter. Anything else we need to address today with Mr. Oliveras?
No, Your Honor.
And if you talk to him, he needs to go to APD to get fingerprinted on this file.
Okay.
Okay?
Okay.
All right, thank you.
Thank you.
All right, I have Mr. Looney back. Ms. Underwood, how do you want to proceed on behalf of Mr. Looney?
Your Honor, good morning. The offer on Mr. Looney is Mr. Looney will plead guilty to a added count of attempted assault of a prison employee, a 2.5-year felony. We would request a COBS to the low end of the guidelines, and Mr. Looney would wish to be sentenced in person. Mr. Looney will accept that offer, Your Honor.
Mr. Sneen, correct recitation of the plea?
Yes, thanks, Judge.
All right, Miss Adams, you know my little whiteout tape thingy? I'm out of the whiteout stuff.
Okay.
And I actually use it a lot, so. All right, so Mr. Looney, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, very good. Can you state your full name on the record for me?
Rodney Jesse Looney.
All right, so Mr. Looney, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an added count 2, which is attempted assault of a prison employee, with the understanding that you would be sentenced to the low end of the guidelines?
Yes, ma'am.
All right, do you understand that the sentence you are currently served, are you in prison or jail?
I'm in prison, ma'am.
Okay, well, you're wearing oranges, so it kind of threw me off. So do you understand, because the offense occurred while you were incarcerated, whatever sentence I give you will stack on the sentence you're currently serving? Do you understand that?
Yes, I do. I thought it was up to your discretion, though.
Not if you're a prisoner of the Michigan Department of Corrections when the offense occurs.
All right.
Okay. Now, are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Absolutely.
Good. And you understand the maximum penalty for this offense could be up to 2 years in prison or jail?
Yes, ma'am.
All right. Now, other than the COBS to the low end of the guidelines, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
Mr. Sneed?
Yes.
And Mr. Looney, is that correct as far as you're aware?
Yes.
Okay, so I'm going to go through your rights with you. Do you understand that if a guilty plea is accepted, there will be no trial? This means that you will be giving up rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
Yes.
Okay. Do you understand that any appeal from your conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
All right. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
All right. So, Mr. Looney, how do you wish to plead to the charge that on or about October 17 of 2023 in Madison Township in the county of Lenawee that you did commit the offense of attempted assault of a prison employee?
Guilty.
Okay. And all right, Miss Adams, could you send an email to Jacqueline Weiss as well as, well, Jacqueline Weiss, that we do not have fingerprints from Mr. Looney? All right. Do you, let's see. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
I understand.
All right. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
All right. So other than the agreement that was placed on the record, has your attorney promised you any other particular sentence or estimated what your sentence will be?
No.
Is it your own choice to plead guilty?
Yes.
Okay. So Mr. Looney, on February or October 17 of 2023, were you at the Gus Harrison facility located in Lenawee County?
Yes.
And if I were to tell you that that prison is situated in Madison Township within Lenawee County, would you agree with that?
Yes.
Okay. Now, at that time, you were lawfully imprisoned. By lawfully imprisoned, I mean you were either convicted at trial and sentenced, or you pled guilty and were sentenced to prison. Is that true?
That's true.
All right. And you came into contact with a correction officer named Pilar Fidel. Is that correct?
That's right.
All right. And let's see. So did you threaten him with a weapon or threaten to hit him, or did you hit him, push him, pull him? What happened?
No, I threw my tray out the slot and some juice hit her, and as she was it hit her, and yeah.
Okay, so you threw something out the slot and it struck her.
Yes.
All right. Is that correct, Ms. Underwood or Mr. Sneed?
Yes, Your Honor.
People are satisfied, Judge. Thank you.
All right. Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
Mr. Sneed?
Yes, Your Honor.
All right. I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has agreed to Cobb's to the lower end of the guideline, but other than that, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Looney, where are you currently incarcerated at? Are you still at Gus Harrison?
No, I'm at Brooks in Muskegon, Brooks LRF.
Okay.
And
All right.
Muskegon.
Okay, okay. All right, so let me find you here again. All right, so I'm going to set this matter for sentencing on April 12th at 11 a.m. Ms. Adams, can I use 11 a.m.?
At what time, Your Honor?
Well, he's like 5 out, he's like forever away, like 4 or 5 hours. So I don't want to do it at 8 o'clock in the morning.
Judge, you do
So,
have a domestic trial starting at 10.
Yeah, that's okay. I'll probably need a break from that anyway. So how about we set it for 11? So April 12 at 11 a.m. Now, Mr. Looney, they may transport you the day before because of the distance, and you have asked to be in person, and you have the right to be present in person for sentencing. So I'm going to set it for April 12 at 11 a.m. And someone's going to reach out to you and update your pre-sentence report, and then we'll provide that to your attorney. So it's much easier to get in to see people at the jail sometimes than it is at prison. So Ms. Underwood always works really hard at trying to set up Zoom meetings and come down in person. But if she can't, I will give you ample time to talk with her that morning, okay?
All right, cool, thank you.
Not a problem. And be truthful with the probation department about your background and the events that occurred. And we'll see you back in person on April 12th. Mr. Sneed, you make a note that your office needs to do a writ for him to be here in person.
Yes, I did, Judge. Thank you.
Excellent. Thank you. All right, Mr. Looney, you're all set. And Mr. Sneed, I'll get an amended information today, probably.
All right, Judge, thank you.
Yes.
Thank you, Mr. Looney. Okay. All right. So hold on. Mr. Looney, I'm gonna disconnect you, okay?
All right, you have a great day.
Bye. Okay, so Ms. Underwood, I have Mick Phelps and I have Mr. Murphy. Do you need 2 seconds with Mr. Phelps while I take care of Mr. Murphy? Ms. Underwood, do you need to talk to Mr. Phelps real quick?
Real quick, Your Honor.
Okay, so I'm gonna open a breakout room and then Mr. Murphy, I'll move over and take care of Hernandez. So hold on 1 second. Let me close my open breakout rooms. Okay, so Jill, Zoom 2 and Rhonda Underwood, go ahead and join that breakout room. All right, we're back with Mr. Hernandez. Mr. Murphy, you had an opportunity to speak with Mr. Hernandez. Let me find him on my docket again really quick. Because, all right. So, Mr. Murphy, how would you like to proceed today on behalf of Mr. Hernandez?
Your Honor, at this time, Mr. Hernandez would like to take the offer from the prosecution, plead to the OWI felony third offense with the sentencing agreement from both the prosecutors and the court.
Okay. All right. So, Mr. Hernandez, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, so I'm going to need you to speak up so we can hear you better, and you can put your hand down. Okay. All right. So, Mr. Hernandez, you've heard the plea that was placed on the record. Is that correct?
Yes, ma'am.
And you've had ample time to speak with Mr. Murphy about that plea?
Yes, ma'am.
Are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yes, Your Honor.
Now, Mr. Hernandez, do you understand, because it's a third offense, the maximum penalty, if you were to violate probation or get in trouble, could be up to 5 years in prison? Do you understand that?
No.
Well, an operating while intoxicated third offense can carry a maximum penalty of up to 5 years in prison. So say you get on probation and you go on a bender or you get in trouble or you commit another felony, potentially I could give you a year in jail or I could send you to prison depending on what happens. You understand? But if you successfully are on probation and do what you're supposed to do, then that'll never be an issue. Do you understand that?
Yeah, how long would I be on probation for?
Probably about 3 years, 2 years, 3 years.
Mr. Hernandez, do you want to talk to me more at the office about this
Yeah,
before?
please.
Okay, so I'm gonna set this over, Mr. Murphy, I'm gonna set it over to February 28th at 8:30 in the morning.
Yes,
Mr.
Your Honor.
Hernandez, I need you to go meet with him. And then I need you to discuss this with him. And Mr. Murphy, I really appreciate if he decides to avail himself of the plea that you bring him in on a day, not a Wednesday, and just let Ms. Adams know. So pre-trial, February 28th at 8:30 in the morning. Mr. Hernandez, make sure your voicemail's working. Make sure Mr. Murphy has your phone number and make sure you reach out to Mr. Murphy to talk to him before that, all right?
Okay, one question.
Excellent,
one-
all right.
Mr. Hernandez,
All right.
come into my office. We'll talk about that PPO thing as well, okay? I was discussing
Right.
with the court staff about that, so.
Okay, I gotta move on to my next case. Mr. Hernandez,
Thank you.
reach out to Mr. Murphy. Thank you. All right, so Rhonda. You did Barton. You did Garnier.
Your Honor, Mr. Hernandez, I think was the last that I had, so I was gonna go to Judge Olsavers. If I'm wrong, please just contact my office. I'll come back.
I'm looking right now, but I think you're right. So you're all set. Thank you.
Thank you. Have a good morning.
You're welcome. Emily Smith, want to come up to the podium? Mr. Malaro, I have Emily Smith.
Yes, Judge.
All right, is your video turned off?
It's not working, Judge.
Okay. All right, I also have, all right, so this is in the matter of the people of the state of Michigan versus Emily Ann Marie Smith. I have two files. I have file number 22-21177 FH and 23-21352 FH. I have Salvatore Malaro appearing on behalf of Ms. Smith, and I have Isaac Sneed appearing on behalf of the people, along with Darren Coast from Pretrial Services. Let me grab her files and Mr. I have a letter from Darren Coast from Pretrial Services. And okay, so all right, so the letter I have from Mr. Coast is that Emily Smith is still not paying on her 22-21177 file. She has paid a total of $20 on it and currently owes $1,815.
I did just make a payment this morning.
All of it? Okay, I'm not really worried about that as much. To make matters worse, her last swab on January 19 returned positive for meth. She also has previously done jail for testing positive for meth. I did another contempt of court warrant on her for her January 19 positive, but it has not been entered into lien. I spoke with Emily on the phone and instructed her to show in person for January 31 court date, and to bring cash in case I wanted a urine test done. Do you have 20 bucks? All right, Mr. Coast also expressed that he's disappointed with how poorly she's been doing. So I'm going to have you drug tested today. Do not leave this floor. Do you understand? So Mr. Coast, I'll have her stand in the hallway. I believe there's probably someone across the hall that might be able to do the urine test. All right.
We'll get that done. Thank you, Judge.
All right. So go have a seat at home.
Your Honor, if I may.
Yep.
We were looking at having her screened for drug court. Do you know if that occurred?
Did you send a referral?
We did.
All right. Sarah Teskey, just have a seat in the hall.
She was screened and approved, Judge.
Yep. It was approved. So
Oh,
that's
okay.
good. right, Darren's gonna take care of the drug test and, let's see, Rhonda Underwood. Let me bring your client back and let's get all your people taken care of and you on your way. So. I have to make a birthday cake for my 11-year-old coonhound today, Rhonda. So we'll get you out of here.
What kind of cake does your dog prefer?
Well, she's a coonhound, so she eats dog poop. So I think she'll eat anything, but I think I was gonna make something with oatmeal or something, peanut butter and oatmeal.
That's awesome.
Yeah. All right, so Mr. Phelps, we're back on the record. Ms. Underwood, how would you like to proceed with Mr. Phelps?
Your Honor, Mr. Phelps, we want to get him screened for sobriety court. So I would like to put this out for 2 weeks. I also would like the court to consider modifying Mr. Phelps's bond to include release to rehab. His mother is investigating Hope House here in town, Your Honor.
Hope House
would be very appropriate for.
So, Ms. Underwood, what I would say at this point is Darren Coast works with everyone to try to facilitate that. If his mother is able to get him approved, if you reach out to the prosecutor and Mr. Coast, we would definitely look at it again. All right?
Thank you.
All right, so Mr. Phelps, I'm going to set it for a pre-trial on February 28th at 8:30 in the morning, just in a couple weeks. Obviously, if something happens, Ms. Underwood, and you want him brought him in sooner on a day that is not a Wednesday, that would be great. And Ms. Underwood, you'll do the stip in order to adjourn. And Mr. Steen, does she have your permission to do that?
I will.
Yes, thanks, sir.
Okay. All right, Mr. Phelps, we'll have you, and you did the referral for screening?
I will get that referral.
Okay, all right. Thank you. You're all set, Mr. Phelps. Thank you so much.
Thanks.
All right. Okay, so I have in my courtroom, I don't have James Renner. All right, in the matter of the people of the state of Michigan versus James Vernon Renner, file number 21-20539FH and 22-21119FH. This is the date and time set for a request and summons for probation violation. Mr. Renner was notified to appear and show why he should not be held in contempt for violation of probation. He has failed to appear. Actually, he's failed to report since November 7th of 23 or any time thereafter. He is currently here for theft and methamphetamine. So I'm going to issue a bench warrant for his arrest, and I will set bond in the amount of $50,000 cash for each file.
Your Honor, do you have Mr. Goodyear available?
Hold on. I got a bunch of people available. Everybody's in the courtroom, and I got Mr. Goodyear too. So in the matter of Mr. Goodyear, you want to come up? Okay, so Ms. Brenner, sorry about the wait this morning as well. This is in the matter of the people of the state of Michigan versus Brian Paul Goodyear, file number 23-21393FH. I have Rhonda Underwood appearing on behalf of the defendant and Sarah Brenner appearing Assistant Attorney General. This is the date and time set for pretrial. This was adjourned from back in November to monitor payments, I'm assuming. So, Ms. Underwood, Ms. Brenner, where do we stand?
Your Honor, I have had a discussion with Ms. Underwood about the case. The defendant is making payments. However, he still has a huge mountain to climb on this. So I was suggesting to Ms. Underwood that she have a discussion with her client about potentially pleading with a recommendation of no upfront jail and probation. She wanted time to discuss that with her client. So if we could have another pretrial date out, give him more time to make payments, and then have her discuss that with him.
Ms. Underwood?
I would think 60 days would be appropriate, Your Honor.
That's fine.
April
Judge.
3rd at 8:30 in the morning.
Thank you.
Miss Adams, Mr. Goodyear is in person, so could I get the notice of hearing? We'll do the notice, Mr. Underwood, Miss Underwood, because Mr. Goodyear is here, all right?
Thank you,
Judge.
Your Honor.
All right, so you can have a seat back on that bench and we'll get you a notice of hearing, all right? So Crystal, right? She knew, she's like, I'm next. I'm next. All right, okay. In the matter of the people of the state of Michigan versus Crystal Marie Wright, file number 23-21558FH. I have Rhonda Underwood appearing on behalf of Miss Wright. And I have, it's a Dave McCready file. I think it's a Dave McCready file. And I have Dave McCready, but I have Isaac Sneed. Miss Underwood, how do you want to proceed with Miss Wright today?
Your Honor, I will be right up. Okay?
Okay. All right, so she'll be right up. Okay. And now I have Castro Oliveras. Okay.
Might take you.
Mr. Oliveras is not connected to audio. Connected. All right, Mr. Oliveras, can you hear me?
Yes,
Hi.
can you hear me?
Yes, I can. So your pre-trial was at 8:30 this morning.
Oh, I apologize.
Nope, your attorney said that you showed up for court yesterday, so we're fine. So,
Okay.
we handled your pre-trial and yeah, I don't know what I do with it. Didn't we set it for, what does your note say?
Judge, he's set for pre-trial March 1st and a jury trial May 15th. I'm sorry, May 1st and a pre-trial May 15th.
All right, so you have a pre-trial on May 1 at 8:30. All right. So Mr. Oliveras, do you have something to write it down with?
Yes, I'm typing it in my notes now.
That's okay.
All right. And you said March 1st?
May 1 is your pre-trial at 8:30 in the morning. So you zoom in at 8:30 in the morning.
Okay.
And then your jury trial is May 15 at 8:30 in the morning. But
All right.
Mr. Oliveras, I also need you to call the Adrian Police Department and talk to Leslie Keene because you have to get fingerprinted on these files, okay?
Okay.
So set that up, all right?
All right. Do I just go down to the police station and do the fingerprinting?
I mean, yeah, you can just go there during the day, but and talk to Leslie Keene, and I'll have my staff send over to her the Miss Adams. We can email the Leslie Keene the DNA request or the fingerprint request.
Okay.
I think she typically only does them like Tuesday and Thursday early in the morning, I think she said, but you know, all right, not on a Friday though, okay?
Okay.
All right, you're all set then. Thank you.
All right. Thank you.
Miss Weiss? Oh, who's your prosecutor? Is it Miss Weiss? All right. Mr. Sneed, Mr. Daly and Ms. Demont are in person on my pretrial for Mr. Bixler. So I don't know if Miss Weiss can come up. Oh, I didn't know if you could text her. I don't.
Yeah, I'll go down and ask him.
Okay. Mr. Malaro. Oh, we're waiting for Tess on that. So I have a jury trial going right now. It's a medical malpractice jury trial. And so the wise, learned counsel has his young associate sitting next to him there. Look at it on YouTube. All right, come on up with Miss Underwood. All right, so Miss Underwood, you have Miss Wright. So this is in the matter of the people of the state of Michigan versus Crystal Marie Wright, file number 23-21558FH. I have Rhonda Underwood appearing on behalf of Miss Wright, and I have Dave McCready appearing on behalf of the people. So Miss Underwood, how would you like to proceed today?
Your Honor, Ms. Wright is recently employed, so she's going to be back at Martin Rea. We would ask for a pretrial maybe in 3 weeks, Your Honor, or maybe a month, giving Ms. Wright a chance to make some changes and produce something positive for this case, Your Honor, and we would hope that would help matters.
All right, Mr. McCready, any objection to that short delay?
That's fine, Your Honor.
All right, so March 6th at 8:30, and Miss Adams, could I get a notice of hearing, please? Because she's here in person, Miss Underwood.
Yeah.
Because she's here in person, we'll give her a notice, so you won't have to do this.
Thank you.
So March 6th is what I said at 8:30 a.m. All right. So that takes care of that one. All right, so have a seat. Just have a seat back where you were, and my staff will bring out a notice. All right, Ms. Underwood, in the matter of the people of the state of Michigan versus Corey Lee Woolard, file number 23-21450FH. This is, I don't even have, do I have a file? Yes. This is a date and time set for a final pretrial. I have Rhonda Underwood appearing on behalf of Mr. Woolard and Isaac Sneed on behalf of the people. Mr. Sneed, do we know if there was a writ done for Mr. Woolard today?
Your Honor, if I could just, this was a case that Mr. Fleming and I discussed an adjournment with you because we've had difficulty getting into the prison to see Mr. Woolard. I spent my Saturday going up to the prison to see Mr. Woolard. However, that is an extremely thankless task because once you get there, you can't take in your laptop and you can't. So, with all due respect to the court and the court's very generous offer before, I would ask that Mr. Woolard be brought down on a day other than a Wednesday, where I can have a few hours with Mr. Woolard.
All right, so Mr. Sneed, and obviously I understand Michigan Department of Corrections and some of the issues they're having right now. Like everyone, they're understaffed and some closures due to COVID or whatever might be going on. So Mr. Sneed, I had offered that if she was how long, you drove all the way to where?
It's up in Lenox Township. You get on 94 and just keep driving.
How many hours?
2.
Okay, so Mr. Sneed, I'm gonna need a writ to get him here in person so that she can meet with them. And how long do you need for a writ? 2 weeks?
Yes, Judge.
She's right there.
May I have the first name of this defendant?
Corey Woolard, Woolard. MDOC is not zoomed in today, so I don't have him here. So do we want to leave? I mean, it's a 1-day trial. I can schedule 1-day trials. Do we want to make the trial date a meeting and then set the trial over another week or so, or?
Well, no, Your Honor, we have stuff to do before a trial. I'll be honest with you.
That's what I'm saying. You won't be able to do your trial on the.
Right, but I'm gonna need the trial to be set out of the way.
But what I'm saying is, do you want me to leave the trial on as an in-person pre-trial? And that way they'll bring Mr. Woolard that day?
Oh, we can do that, Your Honor.
All right, so Mr. Sneed, what I can do, there's a writ to produce him in person for trial, right?
If I could have a moment to review the file, I don't know that off the top of my head. I don't know if that writ had been processed yet for February 15th, but it can be done today.
Okay, so let's process that for an in-person hearing beginning at 9 a.m.
So the
And
jury
we'll leave it
trial's
on.
off. Oh, it's
We're
on.
gonna take the trial off,
Oh, trial off.
but it'll be an in-person hearing where they have to produce them in person.
Understood.
Okay, so trial will be turned into pre-trial in person. So Ms. Underwood, I'm sorry that happened.
No,
Unfortunately,
it was-
I have no authority over MDOC to allow them to
We
bring.
appreciated the time to talk, Your Honor. It was helpful, but, you know.
I know, all right. Okay, all right, so the trial's off for that day and we will be in person for you to have a conference with them, all right?
Thank you.
All right, so Mr. Coast, Ms. Wright, you want to come back up? Do you have anything else, Ms. Underwood?
Do we have Mr. Al-Muhammad scheduled?
No? No?
No? Okay.
No, he's always here unless.
Okay, thank you.
I don't have, the only thing I have left is Bixler and Ms. Smith. So, why don't you come up to the podium? All right, so Mr. Coast, we had a drug test?
We did,
Wait,
Judge.
Mr. Malaro, are you there? Hold on. Mr. Malaro, can you unmute?
Yeah, Judge, I thought you said Miss Wright. Sorry.
I might have said something, but this is Miss Smith. I'm sorry. So
No
we're back
problem.
on the record with Miss Smith. So Mr. Coast, results?
She was positive for methamphetamines and amphetamines again. Apparently she told the monitor that she did use meth 5 days ago.
All right. So Miss Smith is approved, Miss Teskey, for drug court. That's correct?
That's what I heard, Judge.
Okay, I think that's what I heard.
Yes,
Ms. Teskey.
that is correct. I was talking to you, but I was muted.
Okay, so Ms. Smith, I'm gonna take you into custody today. All right. Are we gonna plead her?
Judge, I didn't know what the issue was.
So
drug
let's talk
court.
about this. So she's been pre-approved for drug court, which is a great program.
Is that just for today? Because every time I come to court, we talk about doing drug court and I wasn't high enough. I wasn't a candidate for it.
But you are now.
Okay.
Okay, right, Sarah? She's pre-approved?
Miss Smith, why did they tell you you weren't a candidate?
I
we
think it
didn't-
was a while back.
Last court
She's
date.
saying we didn't
before that.
know is what she's saying.
Okay, so now she's been approved though, correct, Ms. Teskey?
Yes.
Okay, Mr. Sneed, what is the plea offer on this file?
Your Honor, I don't believe a plea offer was ironed out in with respect to both files.
Who's the prosecutor on these?
It's Ms. McClure.
Judge,
Okay,
may I suggest something?
yeah,
So I have a bench conference with you tomorrow. If we could put this over to tomorrow at say around 8:15. I'll go
no,
talk to
well,
her
hold
today.
on, Mr. Malaro, I've got a civil trial and I have to keep this trial moving because I have another trial next week. So Miss Adams, I'm gonna remand her today.
I understand.
Do you understand? You're going to jail today.
Oh, yeah.
Okay, so I'm gonna remand her into custody. I'm gonna set bond on both files at 25,000 cash surety. Miss Adams, when is the soonest moment I can meet with when is our bench conference tomorrow, you said, Mr. Malaro?
Yeah, we have one on Mr. LaFrance at 8 a.m.
So Miss Adams, can I add this one?
You do have another pretrial and a resentencing at 8:30, and then the bench conference he mentioned at 8.
All right, so my trial starts at 8 o'clock. So if you can be here right at 8 o'clock, Mr. Malaro, that's fine, but at 9 o'clock, I start my trial.
Okay, 8 o'clock it is,
Okay.
Judge.
Okay, so I'm gonna set a bench conference for tomorrow morning at 8 o'clock with the attorneys, okay? We'll figure out if there's a plea offer in this file. Mr. Malaro will communicate that with you. If you wish to accept it, I'll get you in to plead. And then we'll set sentencing as soon as we can. Understand at this point, you're probably looking at a sentence to rehab. You understand? Okay, so do you have anything on you? And I'm asking you now because I don't want you to get charges at the jail. Do you have anything illegal on you?
No, I just have my coat and my wallet.
Okay, so I'm going to set this to tomorrow morning at 8 o'clock for a bench conference. We'll set another pretrial. You'll get some notice for that. Mr. Frost is going to take you into custody, Deputy Frost, okay? All right. Okay, very good. And I believe that we may, I'm signing the bench warrant and I'll enter a plea of not guilty for her today on that bench warrant, because we're gonna talk to Mr. Malaro tomorrow. And okay, so that takes care of Ms. Smith. And I need a rubber band. All right, and I believe now is our bench conference on Mr. Bixler, correct? Okay, so I believe that we have concluded our morning criminal docket.
Your Honor, I would indicate it's not a bench conference, it's actually a objection to motion hearing.
Okay.
You're done with me, Judge, then?
I believe I am. Let me check. Yep, looks like I've got everything taken care of on my docket. All right.
Thank you, Judge.
All right. Okay. All right, this is in the matter of the people of the state of Michigan versus Ricky Nelson Bixler. File number 2023-21315 FC. I have James Daly appearing on behalf of the defendant with co-counsel Katerina Demont, and I have Chief Prosecutor Jacqueline Weiss appearing on behalf of the people. This is a date and time scheduled for hearing. The prosecutor filed an amended prosecution's notice of intent, and then I received an objection from Mr. Daly, and then also a response by Ms. Weiss. So are we ready to proceed on the objection?
Yes, Your Honor.
All right. And do we proceed with the objection first, or do you want to start with your motion you stood? So.
Well, I filed my motion under 76827 and MRE 404.
So you got to stand from the podium.
I apologize. And amended it to include MCL 768.27B. I believe that the defense counsel has agreed that the evidence is relevant to the matter. And the only thing they're objecting to at this point is the balancing test. I would ask defense to indicate what their theory of defense is for the court, so the court can make a determination, and I would further argue after hearing that.
Okay. All right. Mr. Mont?
Your Honor, first of all, we're arguing this evidence is 30 years old, and it does have to suffice MRE 403 and be more probative than prejudicial. This evidence is incredibly prejudicial towards Mr. Bixler, and allowing it in versus a conviction based on prior acts as opposed to the specific evidence in this case. The sexual assault allegations and evidence also has to comply with MRE 403, the balancing test as well. Whether or not there's a proper purpose indicated by the prosecution, they still have to get over the hurdle of MRE 403, and that's what we're arguing they can't. With regards to that, we would ask the court to deny the prosecution's intent to admit the other acts and let this charge defense stand on its own merits as opposed to prior acts evidence.
Ms. Weiss?
Your Honor, I'm asking to clarify the theory of the defense's theory for trial, so the court can determine whether the evidence, what the evidence's probative value is.
Your Honor, at this point, the only thing we're concerned about is the prejudicial impact on.
Okay, so there's a misunderstanding. I'm just gonna indicate if the whole defense is it wasn't me, I didn't do it, then the evidence is extremely probative, and it goes directly to the defendant's scheme and plan and way of doing things. The court has my objection. The court has all the facts to make that determination. I would indicate that Bixler was a stranger in all three incidents. He walked in without warning. He was armed with 2 weapons in all 3 of the incidents. He asked for money first in all 3, ordered them all to take off their clothing, ordered them all to lay on their back. All 3 of them were then sexually assaulted. All 3 of them were told to stay put and not move for a period of time. Ms. Dumont indicated that the priors occurred over 30 years ago. That is true, although they all occurred within 1 year of each other. I think I've detailed this in my brief, and I would ask the court to allow that other acts evidence for all the reasons stated therein. And I would just reiterate the probative value in this case is substantial, and it is not outweighed by any prejudicial effect.
Anything else?
Your Honor, we would just argue that if the prosecution intends on bringing this case, they should just use the evidence with regards to this case, and that if they have enough of that, including DNA evidence that they intend to use, then they should try to get the conviction on Mr. Bixler using that as opposed to these other acts evidence in different cases.
All right. In People v. Dobeck, 274, Mich. App 58, 732 Northwest 2nd, 546. The Court of Appeals in that case found that evidence of defendant's other sexual abuse against the victim, in that case it was defendant's stepdaughter, sexual conduct towards his daughter-in-law and a babysitter, was admissible under MRE 403. The evidence was highly probative on the issues of common plan, scheme, or system in defendant's criminal sexual conduct trial. The probative value was not substantially outweighed by the danger of unfair prejudice because defendant attempted to use the allegations of numerous sexual assaults to his advantage to attack the credibility of the complainant, considering the small home and many residents. In this case, the alleged offense here was dated November 28th of 1992. The two prior offenses that Ms. Weiss wishes to bring in occurred within 1 year of this. And so I am going to deny your objection to their notice of intent. Anything else?
Your Honor, I did speak with Mr. Daly. We do have a set of stipulated jury instructions. They just haven't been signed and filed. We will get those to the court today. I believe everything else is filed and we're